Hi, everybody. Good evening, everybody. Thank you for coming for another event of Delmarva REI. So we're excited to have you. I feel like every time I come over here to the group, it's getting bigger. And you know, I'm saying bigger is like more people coming in, yes, but as far as the room quality of the people here, it's amazing. So thank you for coming over. I appreciate it, everybody. So a couple announcements. I guess I'm Alex, by the way. My wife and I started this REI meetup about April 2022, so almost a year and a half. And we kind of saw the need that everybody needs to be kind of connected with people and investors and service people, kind of have the connection with everybody. And tonight we have another great people from Lakeside Title. We have Diana and Raina.
Hi, everybody.
And they're amazing. And we're going to share some info about the companies, LLCs, entities, like why and why not. But I will hand them over in a minute. If you guys are interested, we just launched a new website, delmarvarei.com. We're going to have a forum there. We're going to have email, just email blasts once or twice a month with video recap, some blog posts about everything and more information. And of course, our Facebook page is open to everybody. And connect with me or anybody in this group. I'd love to hear from you. So Diana and I, actually, she met my wife in an education meeting, and I said, oh my gosh, she knows so much, so many people. We have to get connected. And then Raina is graciously came over today and talking about all this legal stuff, which I don't know too much. But thank you so much for coming. And we're going to have a bunch of questions in the end too. But thank you so much. I'll let you guys have it. Thanks.
Do you want to say a few words, or you?
I just want to thank you guys so much. Thanks. We were super excited to be asked for this month and to be able to, I've learned a lot just being in this group. And the Facebook feed and there's so much support in this group. It's been awesome. The referrals that get exchanged, I was just saying to Alex, I love the way you guys are like, oh, well, he's great at that, or she knows that. I mean, it's really a group of supporting one another and not, I don't sense the competition in that. And that's powerful because as Melissa and I, we met yesterday, and as we were talking, I mean, when we refer to each other, our businesses are actually growing immensely. We overlap a lot. So I'm just excited to be here, and I'm grateful that Raina can be here. She's been a wealth of knowledge for me to learn from, and she'll kind of take it over, but she's a great resource.
Well, thanks for that build-up.
It's
so
true.
I'm Raina. I'm one of the attorneys at Lakeside. So I'm going to tell you that I am a very cautious person by nature, and I appreciate that all of you investors who want to jump into this real estate world, and you need to give yourselves a pat on the back because it's a really scary time, frankly, to get into investing in some aspects. Just so you know, I've been on all sides of things. I have been a landlord, I've flipped properties, I've done 1031s for myself. To be honest with you, right now, as I stand here today, I am nothing but my own principal residence over in Ellicott City, Maryland. And every time I say to my husband, let's get into real estate, he says, can we spend more on cryptocurrency? And I said, okay, no. So anyways, so you know, again, it's all about risk, right? And risk tolerance and risk reward. So I'm also going to let you know that I'm a big PowerPoint person. So now I know that Alex says he can bring me a screen because I love my PowerPoint. It keeps me on target whenever I'm doing continuing education courses. I'm like, okay, I know which slide I'm at. I can time myself. I know I'm not going to keep these people inordinately late. But I'm going to talk about a little bit about entities, and then I'm going to talk to you about some of the things that you really should keep top of mind. And I'm going to start by saying something that I tell all of my clients. You never want to end up, has anyone heard the acronym FAAFO? FAFO? It means fuck around and find out. Do not skirt the law when you're doing things. Don't do things on the cheap, because I'm going to delve into a little bit of some of the cases and the suits I've seen against investors and flippers, and they're not pretty. And it invariably happens when, let's be honest, who here has an LLC already? Or some business entity, right? You can get one like that, right? You can go up online, you can get one, you can get documents, oh, Is there anything, is she okay? Oh, okay, all right. Okay. I just know there's a baby over there, glass. I'm like, what is it? So, LLCs, to start off, really, they are an unincorporated business organization, right? And they can be comprised of members. A member can be a single person. You can have multiple members. The members can be other business entities. Any permutation of things can come together to create the LLC. It's very easy to form an LLC, right? Like I said, go up and file your articles of organization at SSTAT, pay your money, get a resident agent. You're kind of good to go. How many of you have operating agreements? Good. That's actually very encouraging to see. So, what we find is a lot of people don't, as I say, you want to be a duck, you need to quack like a duck, walk like a duck. I see a lot of people who start LLCs and they mingle and mix, and they're not necessarily keeping things as segregated as they really should be for protection purposes, okay? So what does an LLC really do? And again, LLCs only exist because state legislatures created a statutory framework for them, right? The lawyers got together, the legislature got together and said, let's enable people to create this type of entity that has some protections and has some tax benefits, potentially. Have any of you have ever owned investment property in your individual names? Yeah, okay. Do you feel safer having the investment properties in an entity overall? Yes, one person does. I see other people saying not necessarily, right? Because it's not necessarily the case that you're going to be significantly protected by having an entity or having several entities. So, when you create the LLC and the LLC owns the piece of property, it's not you who owns the property, you own an entity that owns a property. You may own several entities that own several properties, right? Okay. So, it's all about how do you want to structure it, and I'm going to tell you the first thing you need is a really good CPA. And again, most people are starting small. Most people aren't going out there and saying, look, I've raised enough capital to have this multi-conglomerate thing going on, right? But you're starting small, but you need to lay the groundwork for your more global expectation and expansion. And I'm telling you, the best thing you can do is get a good CPA, get a good insurance agent, and figure out what are the best insurances. I mean, I know there are insurance people here, right? It may be that when you talk to your insurance person, they say, hey, a good umbrella policy with you owning the property with your spouse or in your own name and keeping your primary residence as tenants by the entirety is just as good of a protection, right? Because I'm going to tell you as a lawyer, you're never really safe. You're never really protected. Because what do lawyers do? They throw out the biggest net possible. And we sue everybody because we want to know which one is going to result in the bigger payoff for our client. So who am I going to go after? I'm going to go after everybody I can put in that pot. Some may pop out of the pot because maybe they're judgment proof. They don't have any assets that I can attach to, right? How many of you have ever had a judgment that you tried to collect on? Has anybody ever done that? Where like you've sued somebody? Yeah. Were you successful in collecting? Yeah, did you get garnished? And you didn't have people like skip jobs, I mean, it's kind of like that with child support where people just, oh, I'm going to bail on this job, get another job. So, lots of times the things that are out there in the law to help you don't really result in any beneficial result to you. You're chasing yourself, you're spending money, and you're not necessarily recovering. I mean, traditionally, judgments have a less than 1/3% collection, right? So, yeah, I'm sorry you had experience with that, whether it's a tenant or, whatever it may be. Yeah. Okay, so what's the difference? So obviously, you can have partnerships, you can have corporations, right? There are different entities, and you want to know which one is the best for you. In order to do that, you need to know what's your long-term goal with this. Do you just want to start one corporation? Do you want to start one LLC and have it have multiple properties? Why would you think that you might not want to have one LLC with multiple properties in it? Anybody have an idea why you might want to have a separate entity for each property that you buy? It's liability, right? It's the assets, right? If you put more properties, if I have one LLC that owns property at 111 Main Street, someone gets hurt at 111 Main Street, they can only go after the assets of 111 Main Street LLC. If I have an LLC and I put 5 properties in it and someone gets hurt at 111 Main Street, they can come after all those assets that are in that LLC. So, you know, again, you have to analyze what's my expansion plan, what's my end game here, how much do I want to invest, because it does cost money. And I'm going to, again, bring it back to, you really need to get with a CPA if you're not already. You need to have an attorney probably to look at things and kind of give you advice and guidance on what might be the best. And you certainly need a good insurance agent to talk about options. So, you know, unlike a corporation, right? A corporation has to have a board, and they effectuate their business through the board of directors. They are shareholders. An LLC is run by the members of the LLC. So there's a lot of flexibility because members can do a lot of things without a lot of oversight. And you know, what's key is that operating agreement, okay? So a lot of times, and I'm going to tell you, as a title attorney, we see entities and LLCs that own property and they're going to sell it, and we say to them, okay, here's what we need to see. We're going to verify that you're in good standing with SSTAT. We're going to get your articles of organization. We're going to want to see your operating agreement. And I can tell you that 9 out of 10 single member LLCs do not have an operating agreement. They just don't. It's mom and pop LLCs, they don't have one. You need to have one for many reasons, okay? Because if you don't have one, right, it's the key document. It's the contract that once it's signed by the members, it's binding, not just on those members at that point in time, but all the members that come later. If you assign your interest, you sell your membership interest, it's binding. So if you don't have an operating agreement in place, what can happen if things go south? And I mean, how many of you have multiple member, or most of you just single member LLCs? You have, okay. You know, if it's single member LLC, okay, you're probably not going to get too much of a conflict. Who are you going to have a conflict with? Unless you have multiple personalities, right? You're not going to get in a conflict. So, but multiple members, you need to know what's going to govern if things go south. Well, in the absence of an operating agreement, and I have seen when things go south in the absence of an operating agreement, what happens if you don't have an operating agreement, and let's say that there are 2, 3 members of this LLC. They're not getting along. Or let's say one dies. What's going to happen to the LLC and the interest? If you don't have an operating agreement that officially states what happens in the event of, you know, do you want to have a right of first refusal to other members? Do you want to have, what kind of succession plans are there for this? What's going to happen is the laws that exist on the books of Maryland are going to control, or whatever state you're setting up your LLC in. And there may be very good reasons. I know we were talking, Harold, about setting up an entity in another state. There may be very good reasons to set up your entity in another state. That's something, again, to talk to a lawyer or a tax person about who knows maybe more global tax ramifications. But again, in the absence of an operating agreement, you're going to be just going by, it's just like dying without a will, right? You're going to be stuck with intestate succession. And who's going to get your stuff? Probably someone you don't necessarily want, right? If you don't plan for it. So that's really important. Again, why do you need a good business operating agreement? You got to protect the limited liability status. That's the other thing. Operating agreements give you protection, right, from personal liability. Even as a single member, if you don't have one, you're jeopardizing your personal liability. The whole point that you want this LLC is for liability immunization, right? Everybody wants that, right? Don't you want a buffer between your personal assets and your tenant or your contractor or whoever gets hurt on your property? Of course you do. But you will jeopardize that if you don't follow the rules. So again, because it's a statutory creation, follow the rules, follow the statutes for setting it up, have an operating agreement, right? You want to have it so you don't have verbal agreements. Who's going to enforce a verbal agreement? Nobody, right? You need to have that operating agreement for a reason. And again, those state default rules are often more punitive, right? They're going to set that. So you're going to set all kinds of things in there. Your percentage of the members' interests, your voting rights and responsibilities, your powers and duties of your members and your managers, your distribution of profits and losses, your holdings meetings. You know, I mean, how many of you ever keep notes from your meeting or minutes from your meetings? Good. I'm actually encouraged to see you guys shaking your heads or raising your hand, because I can't tell you how many people that I talk to that really, again, treat it as I did it because I thought it'd be helpful to give me some immunity, you know. And we'll talk about why it not necessarily provides that. So, there are other things. Some people I know will create a limited liability partnership, right? There might be a reason for doing that as opposed to an LLC. Do all of you just have LLCs? I know you might have a C Corp. Anybody have? You have, okay, you have an S Corp, yeah. So, so again, the largest reason for creating the LLC, I think everyone will agree, is to avoid personal liability, right? I mean, is that really your goal, right? Yeah, there's tax issues, but really it's avoiding personal liability. So we all know that personal liability, and like I talk about, we can never eliminate risk, right? Our goal is to try to mitigate risk and try to reduce it in our interactions in business and in life, right? So, I mean, there are people that aren't risk adverse. There are people that will be happy to drive around in a car without insurance on it, without valid tags, without all kinds of things. I know the insurance agent's probably like, I love those people, right? So, and there are others who say, I won't do anything unless I have everything in place. So in terms of personal liability, the protections that it gives you is that, again, your personal assets, maybe you have a lot of investments over here that are in your individual name or another entity name. And you want to keep those completely separate because this rental house that you have in such and such a place, there's a high likelihood. Again, when I worked litigation in Baltimore City, there used to be an old saying, if a Metro bus has 5 passengers on it and it crashes and there's a car accident, how many bus riders file suit? 20. Right. So, right, it's all about liability. So the problem becomes, do you have enough insurance in place? And I mean, I can even ask you, I have a $2 million umbrella policy because of my existing homeowners, and I just looked at the premium I pay, it's $356, right? How many people in here have umbrella policies? Yeah, okay, good. You guys are on top of it. You guys, Diana said, oh, there, so you guys are on top of it. So again, the whole point is you want to limit your risk, and you do that by a variety of things, either creating an entity, having insurance, whatever needs to be done to eliminate your risk. So let me talk a little bit about risk, and let me talk about potential for suits. So can an LLC be sued? Yes, of course it can. If the LLC is sued and there's a judgment entered against Main Street LLC, and let's say that you, this nice gentleman right here, are the member of that LLC. So I sue your LLC and I get a judgment for $2 million, and your LLC has an existing policy of $1 million, and I say, well, I want to get at his assets because I know by doing an asset check that he himself has $3 million over here, okay? So am I going to get at your personal assets? Potentially, I could. Yes, I could. Yeah, it depends on a lot of factors. So, and again, this is where you got to keep it very tight and segregated. Keep your record keeping, keep everything separate. I can't tell how many people start saying, well, I let the LLC make a personal loan, or I paid that vacation with my family from the LLC or from the credit card. I mean, that happens all the time. And there's a lot of mingling, especially when it's single member and it's like, oh, it's a loan and I created an offset over here and I pay it back. I would avoid those kinds of things. It just sets you up for somebody to come along if you ever are sued. And, again, I'm not saying everybody is out there suing everybody, but everybody is out there suing everybody. So let me give you an example of the things that you can't see coming that could hit you. And I know this because I had old historic rental properties in Ellicott City from the 1800s. I know there's lead paint, right? I know there's lead paint there. So what did I do? I did everything I needed to have them certified lead-free, did the sleeves, did everything. Back in that period of time, I was able to get a rider to my homeowner's insurance policy that had lead paint coverage. I know, does that shock you, or do you know that those were a thing at one point?
Oh, no, those are.
Yeah, so I was able to get that because at the time, Maryland had what was called qualified immunity, meaning that if my tenant got lead paint poisoning, I could say, oh no, here's my, I have a rebuttable presumption that it was lead-free. So what happened was there was a suit in Maryland, Dackman suit, that came out of Baltimore City, where this young man lived in a property with lead paint, and the Baltimore City jury returned a verdict against the landlord to the tune of $2.1 million. Okay? When that case hit and they said, yeah, landlord, you're on the hook, it changed everything in insurance, and it changed everything in the state of the law in Maryland, and it opened the floodgates for all that lead paint litigation, right? So the people that thought, I'm doing things right, I'm doing everything I should.
So
Yeah.
what did he do wrong? Like, what was not covered, or what did the lawyer sneak in? There was a
Well, in this case, it was a little egregious. There actually was lead paint that was not fully mitigated. So I'm just saying, but let me tell you a case where somebody is doing everything right, and it still can bite you. And these are the things you just cannot foresee. And this is shocking. And later, if you guys want any of this material, I can have Diana send it to you, or Alex. But you know, I have a lot of investors in Southern Maryland, and a couple years ago, there was a licensed Maryland Department of the Environment lead paint inspector. He was going around and he was issuing lead-free certificates on properties that in fact had lead paint in them. He was just falsifying the documents to the tune of, there were actually 364 rental properties in Southern Maryland in the Tri-County area that were potentially at risk. You know, they were called into question because of the fact that they found some where the people came up with an elevated lead level, okay? So in that case, you know, the landlord, owner, is saying, I did everything right. I had the testing done by a licensed professional that the state of Maryland had on their website. How was I to know that this person was going to falsify a document and then put me at risk? But it doesn't matter, right? Because who are they going to sue? The broke lead paint inspector? Ultimately, in that one case, this lead paint inspection company got fined $5,000. And everybody on that list of homes had to have everything recertified. Some of them had to put tenants in other properties and do the full risk reduction. I mean, so you can imagine, and then you can imagine if there was a lawsuit from it. Not only would you, but your property management gets sued. I mean, everybody gets sued. I mean, so that's a very serious thing. And then I said, well, let me just update and see if anything further has come from those kind of actions. And lo and behold, I see that, yes, there's another lead paint inspector, Home Free Lead Inspection, who just got sued both federally and in the state of Maryland. So again, from September 2018 through the 2019 of November, 219 inspections were done on these suspect properties. 129 or 59% failed for lead-based paint. So this just happened. You know, they right now, 2 weeks ago, they filed suit against, if any of you know Baltimore's Television Hill, which is where the big thing is, because lead paint, they were doing work on the big satellite towers. Lead paint was flying all over. They came and did this thing. So now they're being fined upwards of $10,000 a day for this. So it's just really a scary thing, because again, you could be doing everything right, and then you find out that the person that you had a contract with to do the lead paint inspection screwed you over. And then it's whose insurance is on the line. Yeah, you can sue them. But I'm going to ask you another question, and this is something that I also have seen. The handyman or the person who's working on your property gets hurt on your property. Are they going to sue you? Of course they're going to sue you, potentially. I'm saying, you know, because is there workers' comp? Is there anything? How many of you had somebody work on a property and asked to see their insurance certificates? Did anybody do that? Yes? I would tell you that anybody you have working on your property, not only do you want to make sure you check to see that they have the proper licenses, but that you get a certificate of insurance issued to you, which is easy to do, right? The insurer can give a certificate of insurance saying, yeah, I'm telling you, this guy's got a policy in place of $1 million, professional liability insurance, or whatever, you know, whatever the case is. If you don't check that, you don't have something to go against, and it's yours on the line right up front, you know. So it's just scary to think about all the things that could hit you, you know. And yes, I have seen contractors sue the entity for their, you know, injuries on the place, because they were just there because, you know, they were picked up at Lowe's in the morning and came to work on the house with your guy who you trust. And, you know, again, is it all going to shake out in a court of law? Who knows, right? You've got to prove negligence, you've got to prove causation, you've got to prove all these things. But why do you want to have to spend the money? It costs money to defend a suit. Again, it costs a lot of money to defend a suit, potentially. So you always want to be looking at, again, have you done your due diligence? Even if you set up the right business entity, have you done your due diligence to ensure that anyone you're interacting with is covered, okay, for what they're doing for you? Is your contract a good contract? On that topic, I'll talk about, building permits. Don't skirt those. I mean, they're just, the suits are legion with those right now. I get calls at least 3 times a week from people who have bought their new home and they find out there was no permit pulled for work done on it. I had a young couple who had a fire start in their house, their first night in the house, because the electrical work was not done with permit. Now, yes, a buyer can go out and they can go look in the building permits and see, if it's a flip, first thing I'm going to do, and what I tell clients is go check permits, make sure the permits were pulled, go check. I mean, there was an entire house in Frederick that had to be torn down because there were no permits on it. So there are suits going on everywhere for failure to obtain a building permit. And the cost now that the new owner has to pay to remedy these items. To get retroactive building permits is not fun. You're opening up walls, you're doing all kinds of things that are expensive, and you don't want to be in that position. There's a suit where a broker, I'll get right to you, a real estate agent was sued because in their listing they put $50,000 in upgrades. Well, in discovery it turned out it wasn't $50,000 worth of upgrades, it was about $20,000. So they said, well, just putting it in the advertisement was liability on everybody's part. So just, again, I'm telling you, just try to treat it truly as a business, not a hobby, not a side thing, because the liability that you're seeking so badly could be gone like that. It really could be. And you're just opening yourself up. So, and Joe, I know you had a question.
Can you expand on the Frederick building that was torn down because the permits weren't pulled?
Yes. So first of all, it exceeded what was allowed, even within the building envelope. So that was another big issue. It wasn't built back on the historic. It was on a historic it was a historic property that had burned down. Somebody rebuilt it. You can Google it. It was a couple years back, but and it was a beautiful 3-story gorgeous home, and it was forced to be torn down because it exceeded the building envelope, and that was a large part of it. And even so, with retroactive building permits, you weren't going to get there.
So the envelope, what do you mean by that?
The building restriction envelope is when you're building a new house on the lot. It tells you, or the county has setback lines that say you can't build past this line in the front, you can't build past this line on the sides. So that would be a building envelope for that. So yeah. So again, all of those things are things to watch out for. And I'm telling you, the building permit things are very serious right now. I mean, I don't know what jurisdictions you all work in, but DC has been going after people like crazy. I mean, their clients call me and say, I bought a new house and I received a stop work order. Why would I receive a stop work order? This house was just renovated and flipped. And then I have to tell them because probably no permits were pulled or not closed out. And the building inspectors have been told by most jurisdictions to go around and look for work. And in fact, drones are not your friend, because drones go up and they say, geez, we see an addition on the back of this house and we see no permit pulled for it. So, I mean, that has been an issue, certainly in Charles County on the other shore has definitely had that issue, and Prince George's County. So, don't think you're going to get past things, because if it doesn't come up, right away to bite you, or it'll come up on the next one, or maybe 3 down the road.
So, if you're an agent and your client in their disclosure statement did not put that, are you, as the agent, still liable for things? Or?
You could be. You could be liable as an agent. So if anyone's ever giving you a numerical number to put into a listing of upgrades or alterations to the property, don't put it in. And I'm sure any brokers would tell you not to do that. Don't put in like a number and say $100,000 worth of upgrades, because if you don't have to back that up. What's that? You could just share anything.
You can put like the upgrades include. and
Yes.
then list
Yeah,
them,
that's different.
but
Right.
Never put
the amount. Exactly. Right. Don't put the amount there, because that can really get you. So let me just continuing on before we talk about tax benefits. So the other, thing you need to know is, again, can they get at your assets? Well, how do they do that? So one of the things they do is, if they're going to sue and they're going to try to get to your personal assets, Maryland has been pretty protective about not piercing the corporate veil, which means getting behind the corporation. There are certainly states that are much friendlier to business entities. Everyone knows that Delaware is a friendly state. I know you mentioned Wyoming. Nevada is pretty friendly. California is not friendly. So you kind of look around and see what's there. So what can happen, okay, is again, if I sue you, first of all, if there's fraud or misrepresentation involved, that definitely gets me in around that door, okay? So if it's fraud, which is, fraud in the law is actually a hard thing to prove. It's not as easy as people think to actually meet the legal elements of it, but if I can get that, I'm definitely getting around the door, okay? So bear that in mind. The other thing I can do is Maryland has a statute that says I can get a charging order against the member. Economic interest in the thing. So what happens, and I'll tell you so if you own stock in a corporation and I sue you, I could take control, I could somehow by asset attachment take control of your stocks, right? And then I literally have taken your interest in that corporation. Okay. In an LLC, it's harder to get that because it's not as quantifiable as stock, right? Stock is easy, I can quantify it. So what I want to do when I want to try to get at an LLC member's interest is I'm going to have a judgment, and then I'm going to say, let me see if I can get this charging order. So Maryland says that a charging order constitutes a lien on the economic interest of the debtor in the LLC and requires the LLC to pay over to the creditor, me, who got the judgment against you, only any distributions that would otherwise be payable to you as an economic interest. So I can't really, my hands are a little tied, right? I can kind of get around it, but what might happen is Maryland has been inching a little closer and closer by amending these statutes for charging orders to try to get it so that people can get at them. I'm just letting you know, Maryland's inching a little closer and closer. Now you can foreclose on a member's interest under a charging order, meaning I can take your interest, for what it's worth, or your SNE's interest. So what that means is they can't force you to do things in the LLC. They have no control. If I get a judgment, I can't control your LLC. I can't force the LLC to do things. But what I can do is if there are any profits due to you or distributions to you and they get paid to you, I'm going to take them, right? But what would happen is the LLC would say, well, we're just not going to pay any profits to that member, right? We're just going to keep them over here. We're not going to pay them. So Maryland, as I said, is inching a little closer towards getting around that. And there are several states that are inching closer to that. And it's because the proliferation of LLCs and single member LLCs that, again, aren't necessarily acting like an LLC. So, you have to, again, just, I can't emphasize, find out if it's better. Yeah. No, go ahead.
Is it better to switch to like an S corp or a C corp at that point?
I mean, it may be better again, but it may be better. But even that, I've seen them not keep themselves as tight as they need to. So it's really more about following the rules of whatever lane you decide to get in, whether it's an LLC or a C corp. Follow the rules of that. You know what I mean? Don't mingle things in. And keep it separate. So back to, what's the other benefit than the liability prevention? Is that, of course, you have operating flexibility, right? Members can together run the company. You can appoint a manager. The managers don't even have to be members of the LLC. It can be an outside person. So, you can have a lot of flexibility, whereas in a corporation, no, only the board of directors is going to be acting on behalf of the entity. So there's a lot of flexibility for that. So what are the tax benefits? I think everybody knows the tax benefits are it's a pass-through, right? You can elect, even as a single member, to be treated as an sub-S corp. There's different elections you can make, but most people want to treat it as a pass-through, right? I think that's the goal of most people, is just to have a pass-through, right? How many of you were able to take advantage of that 20% qualified business income deduction? Anybody? No? Okay. So that's I'll talk about that. So that was something that came up in the 2017 Tax Act. And I don't know, there's, again, how many of you have a CPA that you think sometimes steps a little over the line? And sometimes that's a good thing. There's a CPA, everybody, sometimes it's a little bit more subjective, right, to what you can and can't do. I mean, I know CPAs that say you can do this, and I know other CPAs that say absolutely not, for the same exact fact pattern. So, you know, it's about getting a comfort level with your CPA and deciding, do I feel that their advice is sound? Because you also don't want to end up in front of the IRS, right? That's never a good thing, to end up in front of the IRS. But, you know, there was a 20% qualified business income deduction that came into effect in 2017, but lots of times it's kind of a gray area whether landlords with rental property income can take advantage of that. But, you know, it's nice because it's 20% qualified business deduction. So again, you can be taxed as a sole proprietorship, a partnership, an S Corp, a C Corp. We all know what the pass-through is. Your default is going to be a pass-through. In terms of filing tax returns, you're not really filing a tax return as a single member LLC. Multi-member LLC, you do have to file what's called an information report. Again, your tax person should be able to take care of all of that for you. The big thing about a member-driven LLC is that, you know, your profits and losses are generally allocated to each member based on the percentage interest in the LLC, right? So example, you know, if I own 55, you own 45, I'm going to get 55% of the profits, you're going to get 45. However, we can elect to do special allocations. I could say, you know, no, we're going to let this one, maybe a high income member wants to take more of the depreciation. We can do that amongst ourselves as long as we have a nice operating agreement that says we can do this, right? And there may be benefits for that as you grow. There may be benefits if you have multi-members. Again, I think most of the LLCs that we see in investors, unless we're talking about a really large investor, you know, and we have some really large investor clients, are single member LLCs for the most part, and are just holding that down. So, you know, how many of you have an entity where you have employees? Do any of you? Yeah, okay. Do you do the withholding and all that? Yeah, okay, you have your workers' comp, you have everything, right? You do everything right. I like this lady. She's like, every question, she's like, yeah, I got that. So obviously, single member LLCs, generally, you're not going to be an employee, right? And so, you know, you also run into the possibility of there being self-employment tax. So you might have to pay both the employer and employee's portion of this Medicare and Social Security. And again, it gets a whole other mess when you have an actual employee. And that might be a reason to elect corporate tax treatment, is so that you can have employees, right? And they can actually get paid for the work they're doing managing the entity. So are you actually an employee of any of your entities? Yeah, okay, yeah. How long have you been doing that?
15 years.
Oh, okay. So she's got it down, so ask her. She's got it down, yeah. But, you know, that's another thing I see is that, you know, sometimes people have someone who really might be considered an employee, and they're not really doing what they should be doing for an employee, and you can try to call someone an independent contractor and give them a 1099, but it doesn't necessarily mean they're an independent contractor. And so again, that's another thing about liability is, you know, if you get to that point, you know, make sure that if it's an employee, it's an employee, and don't try to skirt that, because those are, you know, common things that happen. Is that, again, that employee gets hurt at a property and they sue, and there's no workers' comp, and it's coming down on you, and it can come down hard. And again, I don't like to talk about all the negative things, but, you know, lawyers are in business because people get hurt and people get sued, and that's, I mean, people don't come to us when things are going great and say, wow, everything's going good. They come to us if they say somebody's, you know, suing me, and I'm scared. What do I do?
So in that respect, if it's a 1099 employee, but we require insurance, and then they let it lapse, we have possible deniability for that, right?
Well, yeah, I mean, if you truly have a 1099 and you haven't managed that way, yeah, there is. I mean, there's always a defense. I'm just saying nothing's absolute, because juries can do weird things, right? I mean, things can happen outside your control, you know. I'm telling you, one time I know a client who was sued. The attorney for the wife said, pay a full year's rent up front. In writing. That tenant wife ended up suing the landlord and won against the landlord because it was full years in advance. Yeah. It was treble damages. So you just don't know what's going to happen, right? And so why put yourself in that position? So in that case, you would think a perfectly great defense would be, I have a letter in writing from her attorney directing that a year's rent be paid up front. So.
Explain your
Oh, for rental?
For a 5-year-old.
So in Maryland, generally it says you can't pay up front, which is why you can only collect 2 months as a security deposit, right? So generally there's a limit on what you can prepay. Now, they've gotten much easier, and in some cases you can prepay the rent.
They can prepay if they do it on their own.
If they do it on their own. You can never require. No, of course, you can never require. But if they do it voluntarily, but even in this case, it was a voluntary payment, and she still came back and said, yes, yes, yeah.
Students that do that.
So you just need to make sure that whatever written agreement that they have sent to you would stand up, okay? So if they're putting it in writing, and they've signed something saying, I want to pay up front in advance, this is rent, this is not a security deposit, this is actual rent.
Right.
You just need to make sure that whatever form that's done on is legally sufficient, is what I'm saying. And it's if it's insufficient, and I'm not a landlord-tenant attorney, so, but I'm just telling you that I know for a fact if it doesn't meet certain statutory requirements, it could be used against you.
Where can I find that?
So the Maryland Attorney General's website,
I know.
the Maryland Attorney General's website has a really good primer available, and they actually have a hotline even. It's www.oag.state.md.us. But if you just do Maryland Attorney General, if you just do Maryland Attorney General, landlord tenant law. Yeah. But it's good to read through that and to see what's going on.
Require it, but they do it voluntarily.
Yeah.
And it's specifically written out separately that your security deposit is this, but if you pay in advance, it's basically we say it's a credit on your account until
Yeah.
it's done.
Yeah.
Like that's what we always say verbally. You never put anything in writing.
No, I would absolutely put it in writing. I would never have a verbal for something like that because that's exactly, again,
Well, I mean, it's an online ledger that they can see that it's sitting as a credit, and they can see what the rent
Yeah.
is and all their charges.
I would definitely advise you to have someone look at that and make sure it's legally sufficient. Yeah. No, I know. I don't want to freak. I don't want to freak you guys out.
Blank addendum,
But
that, like, we'll spell it out in a blank addendum that states that this was the agreement that you agreed to, and then have them sign it, does that, like,
yeah, but you need to make sure that it.
Legally pay it though. That's my thing. If it sits on their account as a
Right. Yeah. I mean, of course, good bookkeeping is always good to have, right? I mean, but there are a lot of people that don't have good bookkeeping. But yeah, good bookkeeping is good, but it's still. They could still say, I didn't understand. If it's not in writing, right? I mean, how do you understand what you contracted for? Yeah, she was suing, saying she didn't want to pay a year's rent in advance. She could have invested that money. She didn't want to pay it in advance, and that it was she was under the impression it was a security deposit. So then it became the landlord, and the landlord was actually a sophisticated investor client. So and he was dragged into the suit. So yeah. Yeah, so I'm just saying, there's lots of stuff out there. So again, get your tax ID numbers for your entities, keep bank accounts. I can't tell you how many people come to a settlement and say, well, I never got a bank account for my LLC. It's just me. Can you make the check payable to me? I know you guys are laughing, but I'm telling you that happens frequently at settlement. And we say, no, we cannot, for various reasons. We can't do it because of RESPA. It's a RESPA violation. We have to pay whoever the record owner is in title. It's just like with trust. People will say, well, just pay me. I'm the trustee of the John Doe Trust. And we say, no, the title holder is the John Doe Trust. We're not going to pay John Doe. That's your job to do your record keeping and distributions under the trust. I mean, we get that all the time. I mean, some people set up trusts for holding investment properties. So, what's another benefit of having an LLC is that if you own the real property in the name of the LLC, you can assign your membership interest rather than having to sell the property outright, and then you can avoid transfer and recordation taxes, right? You can do a sale of the membership interest. So why is that attractive? So an example of that, and Casey, I think, who came out and spoke about 1031s, she does this frequently for her investor clients, is Maryland has a little loophole that says if the real property owned by the entity is under $1 million, you could, instead of selling it, and let's say that if you sold it for $1 million, you'd have to pay transfer and recordation taxes let's say it's 3%, right? So you're going to have to pay a lot of money in transfer and recordation taxes. Instead, what you can do is sell the membership interest to this person. That person then becomes the member of the entity that already owns the property, and you've avoided the transfer and recordation taxes. If it's over $1 million, you can't do that. So, and that's another reason that some people set up multiple LLCs, is so that subsequently they're not selling the real property, they're selling the membership interest in the entity and avoiding transfer and recordation taxes.
So if it's over $1 million, meaning the purchase price or just how much they're financing to you?
Meaning the value on assessment,
value,
yeah.
okay.
Yeah, yep,
Value
yep.
on assessment?
On assessments, yeah.
Like the assessment
That's
from the
on
county?
yeah, on the State Department of Assessments and Taxations. Yeah, yeah. So, so that is a big benefit, and I mean, she does this routinely for clients. Now you're going to pay an attorney legal fees, but the theory is that hopefully you're going to pay, you know, certainly less than you would pay in transfer and recordation taxes to do that. So one of the, you know, again, and it's pretty seamless for that. If you, again, I don't think this is an issue here necessarily, but we sometimes do have LLCs where the sole member is a non-US citizen. And I'm just going to let you know, if that's the case for anybody here or anybody that you know, you could then be subject to what's called the Foreign Investment Real Property Tax Act, which is a tax that's levied on non-US citizens when they sell real property in the US. So if a non-US citizen is selling real property, they're going to get hit with a minimum of a 10% tax, and that tax is on the gross sales price. It's not, it's horrible. It's a bad tax. Okay, but it's the U.S. government's way of saying we want to make sure that if this person's earning income and making money in the U.S., they're paying U.S. income taxes just like U.S. citizens are paying. So, you know, it's a little bit of a sliding scale, but it can be as much as 15%. And so again, like I have, there's a lot of foreign money in certain jurisdictions, you know. So in Montgomery County, we certainly see FIRPTA frequently. In some jurisdictions. So it's not like Maryland's withholding tax, which also comes into play for a foreign entity. Again, if you, let's say, have your entity set up in Delaware, it's a foreign entity to Maryland, right? So you all know about the Maryland withholding tax. You go to sell this property that's in your Delaware LLC, and you're going to get hit with this 8.25% tax, right? And that's horrible. Now that tax is calculated, and that's, Maryland has a non-resident withholding tax, and again, it's to make sure the state of Maryland is going to be able to collect income tax on your investment here in Maryland that you're generating income on. So in Maryland, if I have a property in Maryland, but it's owned by my Delaware entity, I need to make sure my Delaware entity has been registered at State Department of Assessments and Taxations, because if it's registered there, then I can be exempt from that withholding tax. Okay, if it's not registered there.
So you can't own a property from a different state in Maryland and operate it as a rental?
No, so if I start up an LLC and it's in Maryland, and the real property is in Maryland and it's owned by that Maryland LLC, that's all fine, right? Because that's a Maryland LLC. But if I set up my LLC in Delaware, and my Delaware LLC owns property in Maryland, which is A-okay, you can do that. You can set up your entity anywhere. You might want to do that, like I said, for liability purposes or tax purposes. But if my Delaware entity owns Maryland property and I want to sell my Maryland property, I'm considered a foreign entity for purposes of the Maryland withholding tax, and I'm going to have to pay that tax. But that tax is calculated on my net proceeds, which is a little better, even though it's still a bite. The FIRPTA tax is calculated on the gross sales price. No ifs, ands, or buts. So that's significant. So, and we do see it. So again, if anybody is not a U.S. citizen and you're a single member LLC, because it's a disregarded entity, it's going to fall on you. If it's not a foreign,
So why wouldn't you just set up an LLC in every state you invest in?
Well, you can.
Yeah, I mean, that
Yeah.
only makes sense.
Yeah.
If I'm going to invest in Maryland, set up in Maryland.
Yeah. But you can also bring your foreign entity and register in Maryland. You just have to then remember you're going to be paying every year a registration fee, an annual fee. Yeah, yeah,
There's no difference between,
yeah.
it's the same thing as registering over here or anywhere else. It's the same thing, paying whatever money.
Yeah, exactly. Right. You're either going to enroll all those LLCs in Maryland if they own the property, or you're going to keep your states separate, you know. And again, that's just analyzing what's going to best fit you, okay? So one thing that we want to talk about is, you know, some cons for LLCs are obviously financing options. How many of you have ever had an issue where, you know, financing options are somewhat limited with an LLC? Yeah, they are. I mean, it's all commercial paper, and it can be difficult. And how many of you have ever been told by a lender you have to take it out of the LLC in order to get your financing? So that happens, and that of course implicates transfer and recordation taxes, because when you take it out of the LLC, if it's not a dissolution or termination of the entity, you're going to pay transfer and recordation taxes. You only get a break. So if you own property in your individual name and you later create an LLC and you want to transfer that into the LLC, that's different. Yeah. So there are some exemptions in our tax code for transferring property that's in either my individual name or maybe with my spouse or even other people, right? As long as it's what they call a real estate enterprise. And if it's been a real estate enterprise, maybe it's 3 of us that own the property together. The problem is that if we own multiple properties, we've got to transfer all those properties into that LLC because it has to be the identical members to the named people on the current deed. So if it's Jane, John, and Jimmy, Jane, John, and Jimmy better be the members of that LLC in order to get that exemption in. And again, taking it in and out is where you get into the problems. If you're taking it initially in and you meet that criteria, you're good. If you are terminating the LLC or winding it up, you're good, because that's just a distribution to the member. Right now I'm saying, okay, I'm getting rid of my LLC and I'd like to put it back in my name and I'm one of the original members. Or even a corporation could do it as an original shareholder, stockholder. But those are something you want to consider. I mean, and we have lots of people that want to refinance in the entity name and they have to pay the transfer and rec taxes every time they do it, and they're bringing it in and out. And every time you bring it in and out, you're also weakening, you know, the liability immunization that you're seeking, because you're taking it in and out. So what is it? Is it a personal property? Is it, you know, so you want to consider that, is that, you know, you can get into that. The other thing is if you have an existing loan on the property, so this might go more to yours. If I have a loan that was made to my husband and I on a property that we own, but we've been using it as a rental property for a few years, and then we'd say, you know what, let's create an LLC for this and let's transfer that property in the LLC. But my loan is still in the property. Does the lender have any right to do anything if I transfer an LLC? Yes, they do. Of course they do. Yeah. Yeah, they can call the loan due, right? There's something called a transfer on sale clause in virtually every deed of trust on a residential property. It's paragraph 18. It's very standard, and it says, if you add anyone to title or transfer title to this property, as long as I, the lender, have a lien on your property, I can call your note due. And Maryland, I don't see as many calling due. I will tell you, friends of mine who practice in New Jersey and New York see them all the time. All the time. As a matter of fact, I had one client here in Maryland that had an FHA loan, bless you, on her property that she'd been using as a rental. When she transferred it into the LLC, she got a call on her loan. Her loan had only been 4%. At the time they called it, she would have to refinance at what was then 8.5%. This is back in the 2000s. I mean, so that can happen too, right? The lender's going, well, screw this. I'm going to force your hand. I'm not going to let you pay me 4% when I can force you to go out and, you know, get a new loan. So.
Do you know how they found out?
Yes, they have people that they pay to go look in land records or search SStat. And now remember, land records are all online. It's easiest. It used to be more difficult. You'd have to send someone to the courthouse and physically look for things. Now it's just online. So they've got people looking and seeing what's happening. I mean, definitely. So with that due on sale clause, that transfer clause, and I'll come right back to you, there are federal exemptions that say, lender, you cannot exercise that right. But those are limited to very certain situations, like I want to add my husband to the property. If I want to add my husband to my property, my lender cannot invoke their rights to call that loan due, because the federal law says we preempt what you have in your deed of trust, and we're saying that's an exempt transfer. Okay, it'd be exempt if I wanted to add my adult children to my title, if I wanted to transfer it into my trust, right? So there are certain carve-outs for that. But again, it certainly does not cover a transfer into an LLC or any other business entity. So, Joe?
Gosh, sorry. When you said the transfer on sale clause,
Yeah.
what did that person end up doing, and how long did they have to pay back the lender?
That person ended up selling the house. In that particular case, she ended up selling. just because where she was in life. She was a widow, and there were, there were other reasons. So she ended up selling and paying off the loan. But
How long did they give her to sell it?
well, it can be, again, it's governed largely by the terms of the note and the deed of trust that you signed, the original contracts, right? Because those are contracts, right? A note is a contract, a deed of trust is a contract. One's a debt instrument, one's a security instrument. And if I'm the lender, I have rights under both. So, it varies. So, but generally, I mean, if they're gonna go down that road, they're going to try to force it, right? Because generally it sits silent. I mean, how many of you know people? I know people that have just taken over loan payments for somebody or somebody who died, and
So
they're not
now it's gonna
necessarily
happen
looking.
more because a lot of people got 4% interest loans. Everybody wants to buy subject to.
Yeah.
I'd rather buy your loan than buy your property.
Exactly. So those subject to is, again, reason for the due on transfer to be and again, I know subject to are very popular right now. Subject to is, again, that's what you're looking at, is potentially you go ahead and go through this and you get subject to, and that lender finds out about it and says, I'm calling this note due. Yeah, exactly. Yeah, so it's something to consider if you're thinking about subject to. And I know, for subject to, and does everybody know what subject to means? You're buying, somebody has a house that you want to buy, and they have a very attractive interest rate on it. Let's say 3% interest rate, when rates right now are 7%. So I say, hey, sell me your house and I'll just take over making your mortgage payments for you. And then eventually when I sell the house, your loan's going to get paid off and everything will be copacetic. Okay. But, the seller has to understand, hey, your credit's on the line here. If this person doesn't make the payments, it's going to negatively affect you. And your credit's going to be tied up with this loan. And so, once the seller really understands what they're in for, it may not be as attractive for them as they thought. So they're going to get their money for the sale of the house right then and there, but their credit and that loan is going to be tied up. And again, if the person who buys the house and does a off-record assumption, doesn't make the payments, you're the one the lender is going to sue, right? The owner is going to be the person who signed the note is the one who's going to be sued, and all you can do in turn is sue this person, and you're not going to get very far because what contract do you have? You know what I mean? That says, oh yeah, I agreed. So it's all going to be a contract, law thing, and your contract is probably not going to stand up. But the lender's note as a contract is going to stand up. I can guarantee you. And they're going to come after that person and foreclose and do all kinds of things if that happens. And when the market's great, the market's great. But listen, the market can turn. I don't know if any of you were in here, in this market in 2006, 2008 when it tanked. Yeah. Right? I mean, wasn't it scary? I was telling Joe, do you remember getting up in the mornings and there was this website called mortgageimplosion.com, and it was literally every lender that was going belly up overnight. I mean, you'd go on there and you'd say, this cannot be. Greenpoint Mortgage Company. Have you guys ever heard of Greenpoint? They were the second largest lender in the U.S. out of New York, and they were gangbusters. National City. I mean, these were huge lenders, and they just all went overnight. It was just like a forest being cut down, So again, I had investors that were living really large, and it turned off like a spigot. I mean, nobody could believe it, but it was like a spigot. So let me get to some other things. What time are we at? Okay. So when, again, everything about this is just an analysis, your cost versus your risk. You have costs, obviously, in filing every year, setting up the entity, insurances, keeping your books, talking with your CPA, making sure everything's going the way it is. But, somebody asked, are there specific legal considerations when using an LLC to invest in commercial real estate versus residential property? Really, no, because they're all investment properties, right? Unless it's your principal residence, which you're not going to put into your LLC in most cases, then yeah, an entity is an entity is an entity. Whether you're buying so-called commercial or residential, they're still all investments for you. So again, entity is probably what you're looking at. Let's see. Let me see if you had anything else here that was a specific. We talked about, can an LLC hold properties located in different states? Sure. Again, we talked about that. It's just a matter of, do you want multiple entities? Do you want a parent entity that has subsidiaries underneath of it? Another thing, just to backtrack to how you could maybe save transfer and rec taxes, is you could always create a subsidiary And then this is a way that, again, some strategic attorneys, even in our office, help out their clients is LLC A owns this property. Maybe they own 4 properties in this one LLC. The properties combined are way worth more than $1 million. But let's say they want to sell one of the 4 properties, but it's stuck in this parent LLC. So what they can do is create a subsidiary and deed just that property down to that subsidiary, and then sell the membership interest in that subsidiary. As long as it's under $1 million, you're going to avoid your transfer and rec taxes, right? So there can be ways to parcel out things and get them down to where you can avoid transfer and rec taxes. And so that's something that can be done, is take the property down to a subsidiary. But again, you've got to set up a subsidiary, you've got to pay the fines, yeah.
If you have a subsidiary, does it hold up when you're being sued?
Well, as long as it's truly its own entity standing on its own legs. Yeah, I mean, there's nothing wrong with having subsidiaries, but again, treat it like a business, treat it like an entity, okay? So again, it's all about, do you want to have multiple LLCs? I mean, you know, some people say, hey, I'm okay with one LLC. Some people say, I want a different LLC for every property, and they name it literally whatever the property address is. I mean, we see that all the time with people. For financing reasons, you know, how many of you have ever executed what's called an indemnity deed of trust when money has been borrowed? Yeah? Okay. So what that means is I have an entity, and I'm a member of an entity, and I want to borrow money, right, in my individual name. I'm going to go out and I'm going to get somebody to lend me $300,000. And they're going to say, well, Raina, we want the entity to pledge the property for money I'm lending you, because in case you don't pay us, we want to guarantee that they're going to make us whole. They're going to indemnify us, make us whole, if you go belly up and don't pay under your note. So it's a contingent debt for the person who's putting it on their property, or the entity that's putting it on their property. But we see that fairly frequently happen, where a member's getting a note, they're getting a loan made to them, and then we have to get the LLC to pledge the property, okay, as collateral under an IDOT. So again, it's a contingent. It's not your debt until, it's not a lien against property until they default. If they default, then it's a lien against the entity's property. Let's talk about, let's see. So again, I have found that, you know, for me, again, I just have owned properties in LLCs, but I've also owned them with my husband and the two of us, or maybe in just one or the other's name, because we try to keep our T by E properties separate. And I just like umbrella policies, and I like having coverages. But again, you also, and I know this is perfect for an insurance person, some things are not covered by the policies that you have, right? Some torts are not covered by policy. A tort is when it's a cause of action where you've done something to hurt somebody, okay? And some things are going to be excluded under policies, and you always do want to know what your policy excludes. And that's a good conversation to have with your insurance agent, is what would I not be covered for? And think about things, or give examples of things that you might have heard. You know, I mean, this is a perfect thing, like, oh, would I be covered if I didn't get building permits on this flip for my entity? You know, would I be covered? Would that rise to fraud? Would that rise to something? You know what I mean? So those are good questions for your insurance agent. So a lot of times what we have is people that start LLCs, and then because of either market conditions or life or whatever, you know, they kind of let the LLC just kind of fizzle out, for lack of a better term, right? And so what happens is they go to sell then that house, and we have to tell them, well, the entity's not in good standing at the State Department of Assessments and Taxation. So that is a frequent thing that we see, is the entities are not in good standing. What does that mean? Almost always what it means is that you haven't paid your personal property taxes or filed the annual return. That's almost always what it means, is that you're not in good standing with the state. Now, if an entity, which is strictly a statutory creation, is not in good standing with the state, does that mean they can transact business? They can, okay, but title company is going to require them to bring it into good standing. And unfortunately, oftentimes that could be that maybe, like I've had clients that haven't filed personal property returns or annual reports for 5-6 years. So suddenly they've got that $350, yeah, annual fee, And now suddenly they've got all these fines and assessments, and they've got to pay 5 years worth of back, return fees, and they're thinking, is this really worth it? Well, maybe we can work with you because we might be able to say, well, is this your only property that this LLC owns? If it's the only property that that LLC owns and you really don't want the LLC anymore, we could say, well, you're terminating or winding down the LLC, and we could actually allow you to sell that property and do a deed that says this is a winding up, termination of the entity, this is the only asset of the entity, and it's being sold. If the entity has been forfeited, that means it really doesn't exist in the eyes of the law, right? Because that means that the state of Maryland has said you have been forfeited and you no longer exist. We don't recognize you. Now, even if it's been forfeited, there are some code provisions that say we'll still allow you to, and it might not be a bar to a defense. If someone sues you and you're a forfeited entity, you still might be able to put on a defense as an entity, even though you're not legally an entity in the state of Maryland. So it gets complicated. But even in the code, there's a statute that says there's a penalty for transacting business when it's been forfeited. It's a misdemeanor. It has a small fine. But in terms of title, we're looking at it saying, we'll still allow you. We'll try to work with you. But the problem becomes when the person says, well, there's 5 or 6 properties in this LLC that I've let get forfeited, or I've let fall into, not in good standing with the state. That becomes a problem. And then you're going to have to pony up, go up to Baltimore in person, get a clearance letter, file articles of revival with SSTAT, and get your entity back in good standing and get it back as an existing recognized entity in order to transact business. So again, just pay attention to all those annual filings. Don't let things like that lapse. It's, it just creates unnecessary stress. The other thing is a lot of people say, I want to buy this property and put it in the LLC's name, but the LLC isn't yet showing on SSTAT. I filed the paperwork, but it's not yet been finalized. So as a title company, we can't let you take title in an entity that we can't see recognized under the state of Maryland, right? And that's where you get into that, okay, sometimes I'm forced because it's a great deal and they're going to go to someone else if I don't buy it. You might be forced to settle in your individual name and then subsequently transfer it in to your LLC. The problem is that, and again, on the Eastern Shore, they might be more forgiving. I can tell you in some jurisdictions, they're not going to let you immediately put that into the LLC. They're going to want to see a history of you treating it as an investment property. Some counties, they will specifically ask, sometimes longer than that, they're going to want to see tax returns in some jurisdictions that show, yeah, I was treating it as an investment property, here's rental income, here's things we can show you. They want to see leases. I mean, some counties will really give us a hard time. I mean, Howard County gives us a really hard time and wants to see all kinds of things. Their attorney really is, a ball buster over there. She wants to see everything and she'll make you wait sometimes. And so again, now you're sitting that whole time with just your individual name on the deed and exposure. And you've created the LLC, but you can't effectively do anything with it, with that piece of property or multiple properties. And the other thing is, if you have multiple properties, remember, you're supposed to be transferring them into just one entity in which you're the identical member, the people that are in title. So it can get tricky. So if your goal is to do those kinds of things, talk to a lawyer first and make sure you're not going to run afoul of where you're just stuck with the property in your individual name and you can't effectively transfer it without paying transfer and rec taxes, because that's what you don't want to do. So, so that's kind of just an overview of, and again, for tax treatment, I really always advise you. I mean, most people are doing pass-through, but talk to your CPA. They're going to be the ones who can give you the best advice on that, and let you know what's going to work best for you and what structure and what the costs are. And talk to your insurance agent, because that's a huge factor, a huge piece of the puzzle a lot of people overlook and don't think about. And get your insurance certificates from everyone you work with. I mean, everyone you interact with. I mean, even the lead paint people, they had insurance policy. They had a license that hadn't been yanked by the state, but they were doing something really nefarious, right? And exposing people to all kinds of, back on this lead paint issue, there was, the numbers have been decreasing steadily in Maryland, which is a good thing because now it's mandatory. All 24 counties, all 24 jurisdictions have to test for lead paint in children's blood. But, this was an issue that came up in Prince George's County, is that they had 26 children that tested positive with elevated lead level. Well, the majority of those children were immigrant children. And then you get into where did the contamination occur? Did they come to the country with elevated blood lead levels, or was it because they were in my rental property? I mean, you don't know, right? So then, I got the inevitable question, can I ask for a blood test that shows before I rent to them? And then I have to say, well, then you get into issues of fair housing, right? Like, I mean, you don't want to be, discriminating against any ethnicity. You don't want to be discriminating against familial status. So it's tricky. I mean, it can be really tricky for those kind of things. But, there was another case where there was the child was visiting the grandmother who was the tenant of the property. And she was kind of became the de facto daycare. The child ended up with an elevated blood lead level. And they said, well, the contamination happened at grandma's house. So let's sue there, and then you get into, well, where did it happen? But I can tell you this, again, as evidenced by the $2.1 million verdict, you never want to be in front of a jury with a child with brain damage or any kind of, organ injury from lead-based paint. Yeah, I mean, there's just, it's just, like I said, you can be 1,000% in the right. It doesn't prevent you from not being sued. And it costs a lot. Even if you're, whatever insurance you have, if you're deductible, like, for malpractice insurance or errors and omissions insurance, hey, I'm still gonna have to pay up my deductible. It might be $10,000, $15,000, and there's still no guarantee that they're not gonna get a verdict against me and it's not gonna be in excess of what my insurance policy is, and then am I on the line? So it's just forward thinking and planning for, again, never being doomsday, because we couldn't exist and we couldn't transact business and we couldn't do anything. We couldn't drive our cars. There's always risk, right? I mean, you can't live in a vacuum, but it's thinking a couple steps forward and making sure that you're protected. And then, I'm just going to touch real quick, licensing. Oh my gosh, please follow all your rental registration and licensing things. Yeah, I mean, that's just so scary. But listen, I know a lot of people that don't get it, or lapses, or whatever happens. I have a client right now who called. She's got a tenant who's in there under a 2-year lease, and she didn't get her rental license. And she went to get it, and she found out that the entire condo building is not even eligible because the county is suing the condo. So you can't get a rental license in that entire condo regime right now. So she's sitting there looking at a $1,000 a day fine, and now the tenant has her over a hurdle saying, I want you to pay me a whole lot of money so that I go away quietly. So it's bad, you know what I mean? So again, just all those licensing issues, don't ignore it. And if there's required to have your carbon monoxide detectors, your, connected alarms, get them, have them, it's just not worth it, It's not worth it in the long run.
Thank you.
Thank you, guys. Yeah. And I'll be curious to see where you all end up. There's that.
Appreciate it. And anyway, we're going to have this recording available on our Facebook, also on our YouTube channel. If you want to go to delmarvarei.com, just sign up for the newsletter if you want to. You can stay, we have some time here to whatever, just hang out, connect if you want to. Thank you for coming. I appreciate it.